Good morning to one and all present at this inaugural session of our 9th International Conference on Human Rights and Gender Justice, organized by Kerala Law Academy Law College in association with the Center for Advanced Legal Studies and Research. I welcome the prestigious management, all treasured invitees, eminent teachers, and all the attendees. Kerala Law Academy Law College was established in 1966 by the legal luminary late Dr. N. Narayan Nair sir. Since then, Kerala Law Academy has been a pinnacle in the legal arena. The Law Academy is always in its persistent effort to strive to reach out to the star of perfection through an earnest academic pursuit for excellence in the field of legal education, consultancy, research, and pioneering law reforms. It is determined to provide the best stimulating experience to the students to harbor and bring out the polished versions of their talents and skills through its various events of both national as well as international prominence. And before we begin our inaugural session, let's spend a minute in silence to cherish the memory of our beloved Narayan Nair sir. Thank you all. Today we are blessed with the presence of several esteemed personalities on this virtual dais. But right before we invite them to shower us with their pearls of wisdom and knowledge, we have a small video clip in store for you. So sit back, relax, and enjoy.
It's not a game, it's a rich game.
Kerala Law Academy Law College, in association with Center for Advanced Legal Studies and Research, CALSA, is organizing the 9th International Seminar on Human Rights and Gender Justice via virtual mode on 4th of December 2021 from the Kerala Law Academy campus, Perukada, Thiruvananthapuram, Kerala. The Kerala Law Academy, KLA, established in 1966, is a center for legal studies, legal research, and law reforms. Its acclaimed, peer-reviewed research journal has been published continuously since 1977.
While women represent 50% of the world's population, they perform the 2/3 of the working hours, yet they receive only the 1/10 of the world's income and less than 1% of the world's poverty. They grave inequalities between the nations and the so serious inequalities within the nations, and everywhere women are lacking in position and power, overrepresented among the
Gender relations define how people should interact with others and how other relates to them, depending on their attributed gender, and they should be analyzed in cultural context in which they develop. Gender relations need to be measured in the context of participation in and sharing of the important decisions, making process that results in above inequalities.
Through this conference, we aim to highlight the gap differences that is created between gender and how it in many ways has affected human rights, because of which it has resulted in providing a difficulty in legal aid. This international conference on human rights and gender justice is brought with an aim to bring the academicians, students and human rights activists to discuss in one platform to understand the issues that have been arose and to find measures to curb such issues.
Hope you all enjoy your virtual welcome to this event. Leaders instill in their people a hope for success and a belief in themselves. Positive leaders empower people to accomplish their goals. This statement is indeed true for all of us. We have Advocate Nagaraj Narayan Sir, Director, Kerala Law Academy, Law College, Member, Bar Council of Kerala, Special Government Leader, Forest, High Court of Kerala, and Adjunct Professor Noel Scucci. Today, we are all united here because of his effort, vision, and support. From the bottom of my heart, I invite Advocate Nagaraj Narayan Sir to officially welcome our guests into this inaugural session. Sir, please.
Respected Chief Guest, Professor Dr. K.C. Sunny Sir, Professor Dr. N.S. Santosh Kumar, Professor Dr. Usha Tantan, Professor Dr. Yogesh Pradhav Singh, Professor Harindran Sir, Professor K. Anil Kumar Sir, other distinguished invitees, participants, and my dear friends, brothers and sisters. We are having the 9th international seminar after the COVID pandemic. The second wave of pandemic has started. And the pandemic has made us realize the potential of these platforms, wherein we could connect from various places around India, from around the globe, without the difficulty of coming over all these places. And of course, all will, of course, miss the hospitality, the real hospitality of the campus. Of course, I would say all the distinguished dignitaries on the dais should come to our campus, should be part and should know our hospitality, how we are known for our hospitality here, the campus. We look after you so well and so nicely here. And the campus is on the sphere of development. It is going to expand like nothing else. 55 years we have completed. Next 5 years we'll see our campus developing as one of the best in India. And now this is a very important topic because the Indian Supreme Court has made so many contributions, right from the all famous decision of Air India, Nargis Tisra versus Air India. From that decision onwards, even before that, we have seen so many decisions. Now we have decisions like the Shabarimala case, Indian Young Lawyers Association. Maybe it is debatable whether it is on one side or the other side. But the review is there, but still I always go by the present decision. And I always support that decision. And then there is the Nirbhaya cases, then Vaishaga case, 1997, so many cases. And 2017 Shaira Banu case, which has declared unconstitutional, triple talaq, instant talaq. And so many rights of women in personal law. And we are yet to achieve a lot. And the background of the United Nations Declaration on Human Rights and the two covenants, International Covenant on Civil and Political Rights and other covenants, we will be having so much of discussions. And I don't want to enter into any of these areas because the next sessions will all be technical sessions will be on that. I will just proceed to my duty, to my assigned role of welcoming the dignitaries on and off the dais here, the virtual dais. And as a chief guest of today's function, we have Professor Dr. K.C. Sunny Sir. As far as this institution is concerned, he requires no introduction, he requires no welcome. He is a part and parcel of this institution. He has been the man who has built up one of the persons, eminent persons, along with Dr. Jayagumar, Dr. N. Narayanan Sir, my father, with Dr. Jayagumar Sir, his nephew and my cousin, who was the former Vice Chancellor of NUALS. And along with these two personalities, Dr. K. Parameshwaran, Dr. Sunny Sir has played a vital role in developing this institution and bringing about standards. And he was my teacher. And I always recollect with fond memories the days when he was a teacher here when I was a student here. And I would say if I can boast myself, or I can say I have some standard, I have some quality, it's for you to assess. But if I say one reason is Sunny sir, he always insists that I should read standard books and all this. And even in NUALS, as member of the executive committee of NUALS, my father, Dr. Narayanan Nair, was also a member of the executive committee. So I was so closely associated with NUALS even before I became a member of the committee. But I know the substantial difference that has been made to the campus after Dr. Sunny sir has become the vice chancellor. Now, NUALS, the entire thing, NUALS, which were out of the 22 universities, now we have last flat score would show that high ranking people, just after 100, 200 ranks, high ranking people, because people who are beyond 700, 800 ranks will not get there. So the demand for NUALS has raised so much. The standard has gone up. The demand for the institution has gone up, and it has now become a research institution. It has started publishing news publications, research publications, and there was a big makeshift or makeover in the institution, and it has become now one of the best in India, to compete with any of the best in India, with any of the new generation law schools or the National Law School Bangalore and Usha. I should say he was instrumental in this. And his tenure, I would say, is a golden period for the National University of Advanced Legal Studies. He has 30 years of experience. For those who have newly joined the institution, I would say that there are 230 students who have now joined. 30 of those who have newly joined, I would say, Sunny sir, my teacher, was having 30 years of experience as a Kerala University. He started his teaching here. He has a special relation with us. He did his LLB, LLM, and PhD from Kerala Law Academy. Then he was the first rank holder for LLM in the university in the early 1980s. He was a UGC fellow, UGC JRF fellow. With that, he has done his PhD. Then his book, Corrupt Practices in Election Law, is one of the most sought after book. He is an expert in election law. He has 45 research papers. 17 students have completed PhD under him, including 2 foreign students. And such an eminent personality, a part and parcel of our institution, a mentor for our institution. On behalf of all those present here, on behalf of the Kerala Law Academy and all the participants and delegates, I welcome Sunny sir to this function. Thank you. Welcome, sir. Welcome, sir. Next, we have Dr. N.S. Santosh Kumar, Professor, and who is the distinguished Vice Chancellor of the Tamil Nadu Dr. Ambedkar Law University, Chennai, another great institution in India, a great administrator, a great academician, a distinguished jurist. He, after acquiring his post-graduation, he had pursued his PhD in law in the area international acceptance of alternate dispute resolution with special reference to India. And in fact, he has suggested a constitutional amendment, an amendment to the constitution. And it is part of his research output that this amendment is suggested to the constitution, that before invoking the constitutional remedies or any other remedies, judicial remedies, this ADR, alternate dispute resolution, should be made compulsory. And it should be made a part of the constitution. It should be a constitutional right. And that is something which is a very innovative suggestion. And it is based on his research that he has brought up this suggestion. And he has written so many research articles in so many journals, prestigious journals like Indian Institute of the Journal of Indian Law Institute, Madras Law Journal, and international journals. And he has been a resource person and a very important expert in many national and international conferences. He has acted as chairperson, resource persons, presenting many important research papers in many national conferences. So such an eminent man we have here as to preside this function. And I should say we are really blessed and fortunate to have you, sir, here with us for this inaugural function, this important conference. On behalf of the Kerala Law Academy, all those present here and the delegates, especially the delegates, I extend you, sir, Professor Dr. N.S. Santosh Kumar, sir, a very warm welcome to this function. Welcome, sir. Next, we have another very important distinguished personality here, Professor Dr. Usha Tantan, who is professor of the Faculty of Law, Campus Law Center, University of Delhi. Well, my acquaintance with the Faculty Law Center is maybe around 20, 25 years back, maybe in the early 90s. It was the last time I visited the faculty. Even at that time, it was one of the most prestigious institutions in India. The Faculty Law Center 1, 2, Campus Law Center, I've gone to all these places. And I remember the then professors and all, and one of the greatest of institutions in India. One of the institutions which have produced maximum number of judges for the Supreme Court. And even now I know for moot court and all, there will be competition from among 800 people, 700 people are participating for in-house competition in the Faculty Law Center, such a great institution. We are really privileged that we are having such a professor from such an institution here. And she is Dr. Usha Tantan Madam, is an eminent professor of environmental law, population law, and gender justice and family law. And she has teaching experience of more than 30 years. She is a renowned scholar in the world, internationally renowned as a scholar for our work on human development, focusing on environmental protection and women empowerment. Her book on population law in India is the only book of its kind which covers various population issues through the perspective of law and has been referred to extensively in India and abroad, all over the world. She has authored and edited several books on various aspects of law relating to environmental protection and human rights. And I would say personally that environmental protection, ecology, and something which is so personal to me also. And I am a very ecologically sensitive person and a special government leader for forest and wildlife in the High Court of Kerala. We are dealing with so many issues. And of course, Madam, I'm quite delighted that you are such an expert in environmental law, along with the rights of women and gender justice. And here we are extremely happy that, Madam, you are here to be with us, to share your views, and to grace this occasion and make it more enlightening. On behalf of the Kerala Law Academy, on behalf of all those present, and especially the delegates here, I extend to you, Madam Professor Dr. Usha Tantan, Madam, a very warm welcome to this inaugural function. Welcome, Madam. Welcome, please. Now we have another distinguished personality for this function is Dr. Pradhav, Professor Dr. Yogesh Pradhav Singh, who is a Professor of Law of the National Law University, Odisha. Dr. Yogesh Pradhav Singh has received his LLM from the National Law School of India University and his LLB from the University of Allahabad with distinction, with great colors. He has come up. His doctoral thesis is very interesting. It is titled Contribution of Dissenting Opinions of the Indian Supreme Court Judges to the Indian Legal System, a Critical Evaluation. Subsequently, this has been published as a book, and this book is available in the market, Judicial Dissent and Indian Supreme Court Enriching Constitutional Discourse, by one of the best publishers we can obtain, that is Thomson Reuters. That says, because the very publisher Reuters would say that what that book is, how important that book is, one of the most important books which would enrich our knowledge of dissenting opinions, how they are shaped. And we know that the sons, the earlier dissenting opinion of the father is now the major opinion, which has been made the major opinion by none other than the son of the most illustrious judge in the Supreme Court. And we would be coming up with so many other similar judgments. Many dissenting opinions of the past are the present majority opinions, we know. And this evaluation has been a very critical contribution to the understanding of voting patterns of judges in the Supreme Court of India. I'm reminded of Justice Rajiv Dhawan's books on Indian Supreme Court and politics and other books and parliamentary sovereignty, wherein the decisions in Keshavananda Bharati, how the voting pattern of each one has been threadbare discussed. And this is and his contribution will be a constant contribution like that of Dr. Rajiv Dhawan, Devendra Bakshi. I should say such an eminent scholar is Dr. Yogesh Pradhav Singh, who is professor at the National Law University, Odisha. Is enriched by his presence in the faculty. And he is always writing titles in reputed international law journals. He writes for the general public also in popular journals, in New Indian Express, Statesman, and Wire, which is now very live one for all the lawyers, which is even influencing the Supreme Court to think in different fashion. The Wire is actually influencing the judicial system because that has to be there, and very critical articles. And he is writing in those articles, very great. And he has also worked as the Vice Chancellor in charge from 28 September 2020 to 20th March 2021 of the National Law University Odisha. And such an eminent person, we are blessed, we are privileged to have such an eminent person on behalf of all those present here, the delegates and the Kerala Law Academy. And on my own behalf, I extend to Dr. Professor Yogesh Pradhav Singh a very warm welcome to this inaugural function. Welcome, sir. Welcome. Then I also see some very other important personalities like Tanmoy Roy, Dr. Pradhav Kumar Das, who are off the virtual dais. I welcome all those important personalities. Now, another important personality for us is our own principal of our institution, Professor K. Harindran sir, who is a constant inspiration for us, who is the live wire behind this institution. For the sake of formality, I welcome Professor Harindran sir to this function. Then Professor K. Anil Kumar sir. He was a former teacher to me. He was my teacher earlier in this institution. Then he was holding a very high position in a public enterprise. Then he's back in our institution. After he has joined our institution has been changed a lot with so many academic activities and so many policy decisions, which we are cherishing. Each and every student and faculty are cherishing. And on behalf of, and this seminar is also, he is strength behind this seminar. On behalf of all those present, our Professor K. Anil Kumar sir, I extend a warm welcome to you, sir. Then we have, I should be failing in my duty if I don't welcome some of our faculty members, especially the faculty conveners. Apart from that, Advocate Renchini Ponnan Sheila, Assistant Professor, Ajida Nair, Associate Professor, Dr. Dakshina Saraswati, Assistant Professor, Lediga Nair D, Assistant Professor, and Binu PM, Assistant Professor, and also the student conveners, Ajay V, Rishikesh Jay Sharman, Sudhi Kannan, Darshana Vikram, Arjun PM, Sri Durga MU, Gobiga Sashi, Nanda Kishore, Abhirami S, Anandu RS, and Ashik Mohammed M were the student conveners for this, and who have been the faculty members and student conveners have been running around for organizing all this. They are part of this function, but still, for the sake of formality, I welcome you all here. And then so many names which I have not mentioned. They are present here, may not be present. They are running after. On behalf of all those present here, on behalf of the Kerala Law Academy, I extend a warm welcome to all the students, participants, delegates, and all the teachers, faculty members, and students, and everybody here. Welcome to this function, the inaugural function. Thank you very much. Thank you.
Thank you, sir, for your warm welcome. I take this opportunity to welcome you into this inaugural function as well, sir. Today, we are also blessed with the presence of an eminent personality and an exemplary academician, Dr. K.C. Sunny sir, Vice Chancellor, Newell's, Kochi, who has 30 years of experience as a teacher of Kerala University and the Central University of Kerala, out of which 11 years as a professor and 8 years as a dean. After passing the LLM examination with the first rank in the university in 1986, he started his teaching career at Kerala Law Academy Law College, the institution in which he did LLB and LLM. Later, he joined for research with UGC Fellowship and secured PhD. He had published the book Corrupt Practices in Election Law and more than 45 research papers. Sir, with immense pleasure, I invite you for the inaugural address of this session. Sir, please.
Respected Chairman of this meeting, Professor Dr. N.S. Santosh Kumar, Vice Chancellor, Tamil Nadu, Dr. B.R. Ambedkar Law University, Chennai, Professor Dr. Usha Tantan, who is going to deliver the keynote address, eminent professor of law, University of Delhi. Professor Dr. Yogesh Pradhav Singh, professor of law, NLU, Odisha. Advocate Nagaraj Narayan, Director, Kerala Law Academy. Professor H. Professor Harindran K, Principal, Law Academy, Law College. Dr. Anil Kumar, Senior Professor, Kerala Law Academy, Law College. Dear faculty members, distinguished guests, and dear students. Though my role is to deliver the inaugural address, I will take only 5 to 6 minutes because, as mentioned by the director, Dr. Advocate Nagaraj Narayan, I am the part and parcel of this institution since 1980. So I have close relationship with this institution for a period of 51 years. 41 years. Sorry, 41 years. 41 years. Sorry, 41 years. 41 years. Secondly, the second reason for confining my inaugural address to 8 minutes or 6 to 8 minutes is that so many eminent persons are present here to present their views. Professor Dr. Usha Tantan, she is a person having profound knowledge and practical experience in all aspects of gender justice. She is here. Professor Dr. Yogesh Pradhav Singh is also here. Professor Dr. N.S. Santosh Kumar is also here as the chairman of this session. Before going to the subject, I would like to add a few words regarding my relationship with this institution. As I mentioned earlier, I joined in this institution in 1980 after completing BSc Physics for LLB 3-year course. And I was the LLM student, LLM student, PhD research scholar. During that period, I am the teacher also. I started teaching the next day. My LLM result was published. My 30 years experience is confined to full-time teaching experience, excluding my experience as a vice chancellor and experience in this institution. That experience is for another 5 years. Anyway, for all my academic achievements, I owe a debt of gratitude to this institution and to my mentor, the former director of this institution, the founder of this institution, respected Dr. N. Narayanan Nair sir. I have a lot of things to speak, but I would like to cite only one example. I joined here LLB in 1980, then LLM in 1983. Then I joined for research with UGC Fellowship, and at that time I was also teaching as a part of my research work, because at that time the UGC permits research scholars to engage in teaching for a period not less than 10 years. And from 1983 to 1990, actually I was in the Law Academy library, starting from 5 a.m. to midnight. I may go for lunch and other things. And after lunch, I may take some rest also. But I come to this library for 5 o'clock, 5 a.m. because Narayanan Nair sir made a special arrangements for using the library. I can take the books needed out and keep in the guest room, and I can come there at any time and read the book. That was the arrangement. Then one more thing. When I joined in Kerala University as a lecturer, at that time lecturer, that is the starting point. Lecturer, my salary was 4,000 rupees, 4,000 per month. That is in 1990. if I count the amount spent by respected Narayan Nair sir for purchasing books to Law Academy Punnandod Library from 1983 to 1997 years, the total amount may be 50 lakhs. Full set of Harvard Law Review, full set of this Australian Law Review, full set of Yale Law Journal, this full set of US Supreme Court report. That is the intellectual support given by my respected teacher. I am thankfully remembering the support given by my great teacher to me. Then coming to this topic, human rights and gender justice. If I borrow the words of Justice V.R. Krishna here, human rights may be treated as the most important cultural asset of human beings. It is the most important cultural asset of human beings. What is the concern of human rights? I think the human rights intends to promote all things which are essential to individual and collective well-being of human beings. For the individual well-being of human beings and for the well-being of human beings as a society or as a group, realization of certain values are essential. But unfortunately, throughout the history, we can see that there was denial of all values which are essential for individual and collective well-being of human beings. The result is the existence of three basic evils: exploitation, oppression, and persecution. Who are the badly affected group as a result of this exploitation, oppression, and persecution? My answer is that female members of the society. In the history of human beings may be treated as history of discrimination. In this process, which is the section of the society most adversely affected? My answer is female members of the society. The great historian Harare, who wrote the book Human Dios, pointed out that in that book, history of human beings is the history of war, famine, and pandemic, which is the section of the society most adversely affected as a result of these three things, that is war, pandemic, and famine. My answer is female members of the society. So there may be some measures to correct the injustice done to the female members of the society. There are so many initiatives, especially after the emergence of United Nations. There are so many schemes, so many conventions, etc., etc. But even today, the position of female members of the society is not at all better. In this society, there are so many benefits to be enjoyed by every human being. There are so many burdens also. One section of the society is enjoying the benefits, and another section of the society is bearing the burdens. That situation must be changed. Now, the modern history of human beings is the history of constitutional system of governance. What is the role of the female members of the society in the constitutional system of governance? Only in the beginning of the 20th century, even in UK, voting right was given to the female members of the society. Only in 2001, right to vote was given to the female members of the country of Kuwait. That is a position. At the political level also, discrimination is existing. We have to take some positive steps in this regard. What are the modalities to be taken? We can discuss. As I mentioned earlier, fortunately, we have very good resource persons like Professor Dr. Usha Tantan, Professor Dr. N. Santosh Kumar, and Professor Dr. Yogesh Pradhav Singh, and other eminent speakers are also there. I think there may be some concrete suggestions at the policy level, which may be emerged, will be emerged during the course of the discussions in the seminar. With these words, I am concluding. I express my sincere thanks to Advocate Nagaraj Narayan for inviting me. I declare this seminar being inaugurated. Thank you very much.
Thank you, sir, for those insightful words. Next, we are honored by the presence of Professor Dr. Usha Tandon Ma'am, Campus Law Center, Faculty of Law, University of Delhi, who is an eminent professor of environmental law, population law, gender justice, and family law. With a teaching experience of more than 30 years, she's a world-renowned scholar for her work on human development, focusing on environmental protection and women empowerment. And she has authored several authoritative books in the field of law. I'm extremely grateful to invite Professor Dr. Usha Tandon Ma'am for the keynote address. Ma'am, please.
Respected Professor Sunny, Professor Santosh Kumar, Advocate Nagraj ji, Professor Yogesh Singh ji, Professor Hirendra K, other distinguished members, and dear students. Well, I'm delighted to be a part of this important international conference being organized by Kerala Law Academy Law College. So at the outset, I would like to extend my gratefulness to the organizers for making me a part of this conference. Just now, I had the privilege of seeing that documentary which was prepared by the students of this law school. And after hearing Advocate Nagaraj Narayanan and then Professor K.C. Sunny's, whose alma mater is this institution, and I could make out how much attached he is with this institution. You know, all this presentation and addresses has really prompted me, and I'm really restless now to see this Kerala Law Academy Law School in person, to interact with all you distinguished dignitaries, and also to interact with the students whom I have heard in that documentary prepared by it. So my all best wishes for this Kerala Law Academy to grow more and more and to achieve newer heights, to carry on its tradition. And of course, if the persons pay the equal attention, like Professor Sunny, to the, I know the importance of distinguished alumni for their alma mater. Coming from the Delhi University Faculty of Law Campus Law Center, and as rightly pointed out by Advocate Nagraj, that our Delhi University Law Faculty is contributing to the nation, whether it is in terms of cabinet ministers, it is in terms of Supreme Court judges, and many other distinguished personalities. So it's always a learning from each other. So I really want that there should be interaction more and more of the institutions and the persons involved therein. Well, just now I also had the advantage of hearing my predecessor, Professor Sunny, who has talked about and highlighted the oppression of the woman, which had been historical, which had been universal, but which also continues till date. Now, the title of this conference is Human Rights and Gender Justice. Now, this title takes us to two international legal instruments. One, which is already mentioned by Advocate Nagaraj, UDHR, and another is the CEDAW. UDHR, as all of you know, that Universal Declaration of Human Rights of 1948 had already been there. which contains the human rights of everyone, man, woman, everyone. The language used is everyone, every person, and which is also known the Constitution of the world. So in order to understand the gender justice, first of all, we have to be very clear as to why there was a need in the year 1979 to have another document known as CEDA, despite the fact that from 1948, we were already having that UDHR, this document containing the human rights. Now, CEDA, the Convention on the Elimination of All Forms of Discrimination Against Women, why there was a need. If we are able to understand this thing, I think to a great extent will be very clear as far as the foundational questions relating to the women are concerned. Related with it is also another very beautiful I will say experience which we are living. And if I can take the example of our own constitution, we have also to question or see our own constitution, the provisions of it. We say simply in our constitutional law classes that text of Indian constitution is divided into one part which is known as the fundamental rights, and the part which is known as the directive principles of state policy. But if we see it from the woman's point of view, then we come to know that this division is very, very harmful to the woman. Because again, we all know that it is not only the division in fundamental rights and directive principle of state policy, then there is another law which is very clearly written in the constitution itself, that only the provisions of fundamental rights are enforceable, not in the directive principles of state policy. And along with it, when I'm talking about, again, taking you back to the UDHR, we have also to understand that why UDHR, which was a non-binding international instrument, why it was split into two covenants when its status came to be that of legally binding. Why is it that the UDHR declaration, simply this declaration was not made a covenant? Why it was split into two categories? So if we understand these kind of politics behind what we can say categorization of the human rights, we can very easily also understand how the concept of human rights has been affecting the lives of the women. So when this UDHR was divided into two covenants, all of you know that ICCPR, International Covenant on Civil and Political Rights, that means by having two documents, the 5 fundamental rights which were mentioned in UDHR were split, 2 in civil and political rights, and the other 3 economic, social, and cultural rights. So it was not the splitting of 5 articles into 2 group of rights, it was much more than that. So, and that much more than that was, which later on is known as first generation rights, second generation rights, and now when we talk about the gender justice, women issues, we talk about the third generation rights. So if you see the language of these 2 covenants, ICCPR and ICESC, social cultural rights, there you will find that the language of these 2 documents is very different. And the difference, the main difference is that the text, the tone, tenure, language of Civil and Political Rights Convention is very assertive, it's mandatory. And as far as the other document is concerned, which codifies this economic, cultural rights, there it is not obligatory, it is mandatory, it is passive. And the same kind of a thing you will find in our own constitution also, which says a directive principle of state policy also contains the human rights. We cannot say that whatever rights are there in directive principles, they are not human rights. They are also human rights, but they are not enforceable. And now how this is related with the women's issue. Now you see the kind of the scheme, whether it is of 2 covenants at the international level or if it is in the constitutions like India, is like this, that the civil and the political rights which are made enforceable in the court of law are rights which are available in the public life. These are the rights which are available in the public life. And the same kind of a thing you will find in our own constitution also, which says a directive principle of state policy, that means by having 2 documents, the 5 fundamental rights, which were mentioned in UDHR were split, 2 in civil and political rights and the other 3 economic, social, and cultural rights. So it was not the splitting of 5 articles into 2 group of rights, it was much more than that. So, and that much more than that was, which later on is known as first generation rights, second generation rights, and now when we talk about the gender justice, women issues, we talk about the third generation rights. So if you see the language of these 2 covenants, ICCPR and ICESC, there you will find that the to start with, against the state. Now, in between man and the woman, who is the active player in public life? It is man. Now, if we talk about man and the woman, there are violation of rights of the woman also, but may not be necessarily by the state, maybe by the non-state actors. But our constitution says, no, these are the violations that are enforceable only against the state. The violation which is enforceable, the oppression, etc., is against the state. But as far as the women are concerned, they are the victims of the violation of the rights which have been given to them, which we may say are cultural, which we may say are social, which may not be so much there in the public sphere, but they are in the personal sphere. So our own Constitution of India is creating that line, that wall, what we can say private and public dichotomy, which otherwise had been demolished at many places. We find that as far as civil and political rights are concerned, whether I talk about that covenant of 1966 or talk about my own constitution, fundamental rights, there we say that these rights, or this part talks about those rights which are really aware, which we can be sought by the men. Why? Because it talks about the public life, and it is a man who's more active in that particular sphere. But the sphere where woman is more active, and where there is a question of the enforcement of the rights of the woman, or the violation, how to address the violation of the rights of the woman, I'm talking about social, cultural, these kind of the rights, then that is where the women's life revolves around, and that falls under the active principle of state policy, which is not justiciable. So we have to challenge these things also, even though bifurcation of the fundamental rights into fundamental rights, human rights into fundamental rights and relativism of state policy might have been challenged from many perspectives, but the feminists have also analyzed it and have challenged it. And it is because of this reason that there are studies which says that whether it is UDHR or constitutions like this, these may be gender neutral, right? This may be gender neutral. It may be containing those clauses which says there should be no discrimination on the basis of sex, gender, or equality, etc. But at the end of the day, this gender neutral laws are based on what we can say male norms or male experiences or male needs. So what is a human rights model which has been adopted at the time of what we can say having those covenants, or here in our constitution? That is essentially the male model of human rights. Okay. Now, you might be wondering, then how to really frame the law, if it is a question of framing any law, and we are saying that there should not be any discrimination between man and the woman. The law should not discriminate. That means law should be gender neutral, and here the law is gender neutral, and still it is criticized that, oh, it may be gender neutral in form, but in its application, ultimately it turns out to be gender biased. So how to frame the law, how to know whether any law should be gender neutral or it should be gender protective? You know, it's not an easy question to answer. Women issues are very complicated. It's more complicated when we come to the framing of the law, or the law which is already enacted, when we examine it from that point of view. Recently, in 2005, one law has been enacted which is gender specific. We call it Domestic Violence Act, Protection of Women from Domestic Violence Act. Then in the year 2013 also, another law has been enacted, again which is gender protective, or I will say which is not gender neutral. I'm talking about protection of women from sexual harassment at workplace. This. Now, when these laws were enacted, there was a heavy criticism that why these legislations are gender protective, why these legislations are not gender neutral. There were various voices on that. Now, and therefore, I'm saying that in order to understand it, we have to have basic knowledge, which starts right from the UDHR and then the covenants and the other kinds of the things. You see, this also takes us to some of the jurisprudential questions, and that is when we are talking about man and the woman and its relation with the state or with this the laws. Then and we are talking about equality, of course. If we are talking about non-discrimination, then what is the approach of equality? What is the meaning of equality in this context? Is it that in all spheres of life, man and the woman should be treated equal? There should be a formal equality. So is it a principle of sameness which has to be applied, or it is a principle of difference which has to be applied? So when we are talking about equal treatment by society, by the particularly by the state and the laws, there also we cannot deny the fact that we cannot say that man and woman are equal, at least biologically. We cannot ignore the biological differences between man and the woman. That's one of the things. But the problem is, we say we have to understand the difference between the sex and the gender. Male and female, that's fine. Male and female is a biological criteria. But what about man and woman? The problem is with man and woman. The problem is not with male and female. Why? Because when we talk about girl and boy, when we talk about man and the woman, then all that stereotyping comes in. Women should be shy, they should be docile, man have to be aggressive, they should have the muscular power, so on and so forth. So the problem is more with the gender, less with the sex of the person. So if biological differences cannot be denied, how to deal with the gender differences? Should we have the approach again of sameness or difference? Now, if I take that biological differences cannot be denied by anyone, then of course it takes us to the difference approach, that the man and the woman should be treated differently. But herein the problem is not to recognize a difference. The problem is how to recognize a difference. Problem is not to recognize, but the problem is how to recognize the difference. So is it that in recognizing the difference, we should reinforce the stereotyping? Or is it that in enforcing it, we correct that stereotyping, etc., etc. Just to take one of the examples from our own constitution, from civil and political rights, we say that both man and woman have right to work, go out in public, have right to work. Fine. There is a family, husband, wife, 2 children. Practical example I'm taking from our own lives. Both that husband and wife are working and the children are going to school, right? Now, you see the difference in the lives. When the husband gets up and he has to go to the office, we don't have to ask anyone. We have to just see our own families, that what are the kind of the things which the man does. Maybe he gets up in the morning, or at the most goes out to bring the bread and the milk, etc. And thereafter he will be sitting reading the newspaper and enjoying the cup of the tea and all that. And of course, then the lunch will be ready, breakfast will be ready to eat, lunch will be ready to take on, and he will go. Maybe before time he will reach the office. Now take the life of the woman. Woman has to go to the office on the same time. Let's say it's 9 o'clock for both of them. But when she will get up, before leaving for the office, she has to do a host of things. And what are those things? We all know. I need not mention herein. She has to do all those chores at the home, which she has been, any woman who is not working outside is doing. She has to do, or she has to supervise. If she's having certain, in India at least, we are having these domestic help, etc. But even still, she has to supervise all those kind of a thing. So it is here. Now you can understand when I was saying that our constitution contains this model of human rights, which is male-based model of human rights. Okay, it's a formal equality. Both men and the woman can go out and be a useful member of the society as well as of their home, but their lives are different. They're different. Women have started working outside also. This is a change which is quite evident all over the world, here in India also. But men have not started doing work at home. So is it that the law has to come in and say that no, the men, you have to work at home also? So to what extent the law has to regulate all that? Or is it, now here, it's a very serious thing which I'm now discussing before you, because these are not easy things, but if we have the clarity, of course, we can achieve in a very logical manner. So if this is a thing that woman has to work at home before going to office, not before going to office, even after coming from office, after coming for office also. And then how the law should be, if this is the law which is, we are saying the male-based, just now I have said, is it that the law should also say, no, the man, you have also do the work at home also, or it should be like this, okay, if the woman has to do all this kind of a thing, for men, if the office is 9 o'clock, for the woman, it is 11 o'clock. So we are, in both these examples, we are treating them differently. But how to treat that difference? If we are saying it is 9 o'clock for the man, it is 11 o'clock for the woman, that means we are reinforcing those stereotypes. We are reinforcing, oh yes, women, you have to take double burden at home and outside home also. So that is no answer. So therefore, when we are talking about change always happens to be a gradual process. Now, taking you to 2005 example, which I have taken of protection of women from domestic violence. Very, very briefly, I will try to make you understand how this act, being gender protecting, is the right one. Okay. Yes, when the questions are raised, why only protection of women from domestic violence? Is it that men are not victims of domestic violence? If men are also victims of domestic violence, then why the law only for women? This is a very valid question. And whatever questions are raised, we have to give the answer. Unless the answer is satisfactory, of course, we cannot move further as far as our research is concerned. So the answer here is that yes, feminists or the persons working for the women's right are not denying that men are not the victims of domestic violence. They're accepting it. Having accepted it, they are saying that this law, which is only for the woman, is a justified law. How? Here comes a difference. We say that when woman is a victim of domestic violence, she suffers as a class, not as an individual. When man is a victim of domestic violence, wherever there are the cases, he suffers as an individual, not as a class. That's one of the basic difference between the two. And another is, of course, if we go by stats, if we go by the data, then we will find that the number of domestic violence against women are far more in comparison to this domestic violence against men. Third reason, if DV Act 2005 is not giving any remedy to the men who are victim of domestic violence, that does not mean that men who are victim of domestic violence have no remedy whatsoever. In India, they do have their remedies. IPC is there and the other laws are there. These are the things to just answer these questions. Now, there is something more to justify, to say that why this particular act is only for the woman. And here is a very beautiful example also, wherein we can say how the law can be based on, how the law can answer the woman questions. Okay. You see, even though those who have studied the Domestic Violence Act, you know that there's a very, the definition of domestic violence is very wide. It includes sexual violence also, economic violence, emotional violence, etc., etc. And another, that term woman is also defined, which is very, very comprehensive. But I will be talking about only one kind of the woman, which we can say the wife. Why? Because the point which I want to illustrate is best illustrated if I take the example of wife as a woman. Okay, you see what happens. A woman on marriage, wedding, in most of our societies, leave the house on marriage and goes to live with the husband in the house, which might have been set up by the husband or by the family of the husband. Okay, so this is the first patriarchal bias. Son and daughter both are born in the house. On wedding, the son remain in the house, the daughter is uprooted from there, and she goes to live in another house. Okay, law doesn't say that. Law doesn't say. But this is our cultural norms, which we have been following this. Now, it is a woman, daughter, who on marriage has gone to live in another house with the husband. If everything goes well, it's perfectly all right. But the problem comes in. We talk about the law when the things are not good therein. And now this woman, in between husband and wife, if the things are not going on smoothly, then one has to leave the house. Who will leave the house? Naturally, that person who has come to live in this particular house. There is no question of that the husband will ever leave the house. Of course, I'm talking about those houses. I'm talking about general thing, not the exception. If the exception is somewhere that the husband and wife have established jointly, those are different things. But generally, it happens like this, that it's the house of the husband, right? And therefore, how can we have a gender neutral law when the needs in the domestic violence, particularly from the point of view of this a woman, wife, a husband and wife, are different? And as all of us know, that DV Act is that act which gives the woman the civil remedies, because criminal remedy was already there in the IPC. So in the civil remedies of compensation is there, monetary, these things are, the protection order is there. But the very, very important right, which I see, is the residence order. Why? Because she needs, what is residence order? She just need a roof over her head. That is the only thing. And I will not go in detail, because I have to cover up the other things also, but it's a very interesting area. If you see the judgments of the Supreme Courts also, from Tarun Batra now to the Ahuja case, how they have traveled, how many years they have taken. Why? Because in majority of the cases, the house happens to be the house of the husband's father or husband's mother, and then she was having problem of the residence order. What we a residence order is roof overhead. She does not become the owner of that property if she is given the residence order. So this residence order is absolutely inapplicable when we are talking about the remedy of the husband, so on and so forth, right? Okay, so these are very complex issues, not very easy to decide these things. So this principle of sameness and difference also takes us what exactly we want when we are talking about how men and women should be treated by the law. Do we want equality or we want equity? Right? Then, of course, one may jump to say, oh, of course, we want equity. We don't want equality. But then again, there cannot be any universal thing. There may be certain areas where formal equality will do. But then there may be other areas because gender roles are still not being corrected. And we don't want that by getting the rights, because our society is becoming more and more right-based. Wherever there are rights, there are conflicts. And whenever there are conflicts, the law may come to help after 10 years, 20 years, etc. But that the love, warmth, closeness in the family members, we don't want that should also be lost. So this stereotyping is being taken care of, but not in that particular, you may find there are some of the instances where the men are working at home also, and they understand if the wife is working, how to treat her so that reduce the burden. But those are the exceptional cases, still not the still not the norm. So we talk about equity more rather than simply the equality. And when we talk about equity, these kind of the things, whether it is 2005 enactment, whether it is 2013 enactment, can be very easily understood that why this gender protective law is needed and not the gender neutral law, right? Now, gender justice as a subject of study in the university curricula is a recent one. When I was a student in 80s only, in my own campus law center where I'm teaching, Professor Sunny, I'm in my association with my campus law center is more or less like that. That I have in 80s, I received my LLB, LLM, PhD, all from that institution, and now I have the chance to serve it. Okay, so in 80s, all of you, even Professor Santosh Kumar, other panelists will agree, there was no subject of gender justice. At least I have not studied. Why? Because this was not a subject of the curricula. Okay. Then there came a time, if I'm talking about my India, then after the establishment of NCW, after the mid-90s, they have taken up this agenda that gender issues should be introduced in universities, not only here in law schools, in all the disciplines. You talk about any discipline, you will find that gender issues are relevant therein. And then I was a member of that particular committee who was considering on the inclusion of gender justice as a subject. And of course, here from the legal background for the law schools. And so many problems were there because it happens to be also in the meetings, the directors, vice chancellors, and they were saying that, okay, we will introduce, but we don't have the faculty, we don't have the literature, so how we will teach to our students. But ultimately, gradually, because these are the problems everywhere, whatever the new area of study we are including. So ultimately, slowly as an optional subject, it was introduced in the universities. If I talk about my Delhi University, we introduced this paper somewhere in 2004 or 2005. And, initially, the understanding of gender justice at all levels, international level, domestic level, was limited only to women. What is gender justice? Equality between women, ending the oppression between of the women by the system which we call the patriarchy. You take any report of United Nations, you take any other document, you will find the heading gender, but when you come to that particular text, you will find that gender means woman, 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 woman. You come to Government of India, so many schemes have been announced by the government under the name of gender. So heading is gender, but when you come down, you will find that the woman. So gender and the woman became synonymous. But is that the real meaning of gender? Is that the real meaning of gender justice? Justice only between man and the woman? But that was the initial phase of it, initial meaning of it. For the last couple of years, now it is in gender justice, what we have been talking about is the issues of third gender. In our own country, you can mention of 2014, April 2014 judgment from the Supreme Court, NALSA judgment. Now that we are having the act also, 2019 Act, protection of transgender persons, we are having the rules also, and that council, which has in New Delhi, the office, which has been there. So, I will say this discipline of law, gender justice, is still evolving. We can't say, oh no, this is a concept which has gained its meaning, its complete meaning. It is still at this stage of the evolution. It started with women under the name of gender. Now it is talking more of the third third gender. But if we are talking about undergender, women and transgender, will we not talk about the men? Whether men are excluded from gender? Obviously, the answer can be no. Answer can be no. Now, when we are having gender protective legislations, we are also having another kind of a problem that these laws, there are incidents wherein we are saying that these have been misused. The laws have been misused. We cannot turn our blind eye to that also. So gender obviously cannot exclude men also. But again, I am saying it is still at the settling stage. It has not been, this concept has not been settled. And let us see what shape it takes in the coming time. But these were some of my thoughts, which I thought to discuss with you people. And some progress, I will say, has been made as far as women are concerned, as far as third gender is concerned, but there's a long way to go hearing. So with these comments, I thank you for the patient hearing. Thank you.
Thank you, ma'am, for your thought-provoking words. Next, we're also accompanied by one of the most reputed, Professor Dr. N.S. Santosh Kumar, Vice Chancellor, the Tamil Nadu Dr. B.R. Ambedkar Law University, who was an excellent academician and administrator. After acquiring his post-graduation in Commerce, Public Administration and Law, he had pursued his PhD in Law in the area of international acceptance of alternate dispute resolution with special reference to India, and he suggested for constitutional amendments for making it compulsory before opting for judicial remedies. He is also an eminent writer with various contributions in the field of law. I'm sincerely privileged to invite Professor Dr. N.S. Santosh Kumar to give the presidential address to this function. Sir, please.
Thank you. Thank you. Honorable Vice Chancellor, ULs, Cochin, Professor Dr. K.C. Sunny, sir. Honorable Vice Chancellor, Professor Dr. Dilip Uke, Mumbai National Law University. Professor Dr. Usha Tantan, Faculty of Law, Campus Center, University of Delhi. Professor Dr. Yogesh Pradhav Singh, Professor of Law, National Law University, Odisha, and other guests of the day. Dr. Dakshina Saraswati, Assistant Professor of KLA, and all the faculty members of Kerala Law Academy. Mr. Nagaraj Narayanan, Director, Kerala Academy. Professor Harindran, Principal, Kerala Law Academy. Paper presenters, Ms. Anan Azza, Student Moderator, Law Academy. Ladies and gentlemen, very good morning to one and all. At the outset, I thank the authorities of Kerala Law Academy for inviting me for this international conference on human rights and gender justice. As Kerala Law Academy is known for conducting very many international conferences and other refresher and orientation courses, it is not a wonder for them to conduct an international conference on human rights and gender justice. My best wishes always to Kerala Law Academy. On hearing Dr. Sunny sir, his long association with Kerala Law Academy, I to feel that I can call him as son of Kerala Law Academy. Such an extent his association speaks that he is loving that institution like anything, and it cannot be parted with Kerala Law Academy under any circumstances. Yes, sir, live long and let Kerala Academy get all cooperation from you forever. Yes. Once Swami Vivekananda said, the best thermometer to progress of a nation is its treatment to its women. There is no chance for the welfare of the world unless the condition of women is improved. from these wordings, everything comes. What is the status of women in this earth? These 4 lines categorically speaks. Therefore, the status of women has been a topic of great discussion for many years in the past. It encompasses various burning issues of women education, maternal health, economic empowerment of women, and the role of women in the family, community, politics, and more. These are all the areas where we are often searching the degree of gender equality also. Gender equality, also known as sexual equality or equality of sexes, is a state of equal opportunity in resources, including economic participation and decision making. And the aspiration and needs equally, regardless of gender. Gender equality is a goal, while gender neutrality and gender equality practices and ways of thinking that help in achieving the goal. Here, we are in search of the degree of gender justice. Gender justice generally deals with the liberty of women and to promote women's right through legal changes and the participation of women in social and economic policy. It includes drafting strategies for proper action towards transmitting society as a whole to make it more just and equal. It means a place in which women and men can be treated wholly human. Moreover, it implicates moving away from arbitrary to well-reasoned, justifiable, balanced, fair and social relations. Therefore, ladies and gentlemen, gender justice is an instrument to reduce inequalities between women and men. On global scale, achieving gender equality also requires eliminating harmful practices against women and girls, including sex trafficking, feticide, wartime sexual violence, gender wage gap, and other oppressive tactics. But it is heartening to say that one report of the United Nations states that despite many international agreements affirming their human rights, women are still poor and illiterate. They have less access to property ownership, credit, training, and employment. Women are being labeled as child bearers and homemakers rather than the breadwinners of the family. They are far less likely than men to be politically active and far more likely to be victims of domestic violence. See, from this report, one can very easily come to a conclusion that the status of women in the society is not at all improved as on date. Ladies and gentlemen, we all know that our Indian Constitution commences by saying, "We the people of India," which comprises men and women in all caste, religion, etc. It persuades dignity of individuals, which also comprises dignity of women. Therefore, our empathetic constitution, the fountain of laws, is gender conscious. It is not only allowing equality to women, but also empowers the state to adopt a system of positive discrimination in favor of women for nullifying the aggregate socio-economic, education, and political disadvantages suffered by them through its different situations. This itself is enough to get gender justice and gender equality. But what is going on? If this international conference with the prospective outlook analyzes this issue constructively, that is enough to achieve the objectives of this conference. We all know that based upon the various provisions of Indian Constitution, our judiciary also plays a pivotal role to maintain human rights and gender justice. We have come across a lot of cases. You, the participants, are well aware of all these cases, but still, I want to note, for the purpose of igniting your thoughts towards this field, though we have the legislative recognition as well as judicial recognition. For that sake alone, I am referring all cases. We have seen that Valsamma Paul versus Cochin University and others. It has been held that human rights of women encompasses gender justice. And it is also accountable to the convention for elimination of all forms of discrimination against women. Human rights for women, comprising girl child, are inalienable, integral, and an indivisible part of universal human rights. It is categorically stated. In Singh versus State of Uttar Pradesh and others, the court has recognized under Article 21 of the Indian Constitution, wherein it has clearly stated the person has complete rights of control over the body and organs. It also includes the absolute right of a woman over her reproductive organs. The same is the case with Vishaka. See, you please note the exact wording of the Honorable Supreme Court of India. In Vishaka versus State of Rajasthan, the court throws light on increasing the menace of sexual harassment and observed in each incident of sexual harassment of women at workplace is a violation of her fundamental rights of gender equality and the right to life and liberty. Categorical statements. It clearly gives a boundary where exactly the rights vested with. Ladies and gentlemen, note this point also. The legislature and the judiciary are in one hand to achieve the fruits of Indian Constitution in the case of gender justice and human rights. Still, why we are unable to succeed? Somewhere, some mistake. Still, we presume that the implementation part have some setbacks. Or shall we presume that executive fail in that point of view? If you don't agree, then how to get gender justice and gender equality? Why I am telling is, one way, judiciary is clear with its hands that they cannot compromise with women's rights under any circumstances. Other side, the state is enacting a lot of laws wherein they guarantees the rights of women. Now we are unable to accept the failure on the part of the executive to implement the judgments as well as the legislative provisions. Then, how to get gender justice and gender equality? Ladies and gentlemen, there are evidences where even laws and customary practices are discriminating women. It is another headache. In the name of Hindu law, in the Hindu law, till its codification in 1955 and 1956, the Hindu women did not enjoy equal rights along with men, Hindu men. Before 1955, polygamy was common among the Hindus. the Hindu woman could not hold any property as absolute owner, except in the case of Sridhar. J.L. Nehru, an important author, said that the British policy of non-interference with the personal laws and the mechanical interpretation or perpetuation of Hindu customs stop the natural growth of Hindus and gives rise to petrified rules. You may be knowing that in Geeta Hariharan case, the provision of mother condi, natural guardian of her children during the lifetime of her husband, when the issue relating to mother as natural guardian was questioned. But the court held that the relegation of mother to inferior position to act as a natural guardian is a violation of Article 14 and 15. After that, the guardianship right of a woman has undergone some modifications by this interpretation. You all may be knowing that what extent the personal laws are discriminating women, but the judiciary did not allow this discrimination under any circumstances. What happened in the case of Sarla Madgal versus Union of India? It was found that conversion of Hindu male to Islam only for the purpose of contracting bigamous relations. Under section 494 of the Indian Penal Code, such marriages are declared as bigamous and void by the court. The court, after making a reference to various precedents in this matter, categorically held that till uniform civil code is established, for all the citizens would be an inducement to Hindu husband who wants to enter into second marriage is subsisting to become a Muslim. Here, the second marriage is always being treated as not a valid marriage. If he proceeds with the second marriage, as long as he remains in the Hindu and with the exclusive purpose of getting second marriage and adopts Muslimism. Here, the court throws a light on the injustice to the legally wedded first wife. It was also noted by the bench that there is a failure of successive governments to implement the constitutional directive under Article 44, and also suggested that the personal laws of the minorities should be rationalized to develop religious and cultural amity, and advocated introduction of uniform civil code in India. But at the same time, Lily Thomas versus Union of India, though it rendered justice to the victim, but it has taken aback from uniform civil code issue and it pleaded its inability as long as no clear-cut laws are available. Ladies and gentlemen, this is the biggest problem now. The personal laws are even giving or allowing to practice discrimination from the opposite sex. You all may be knowing that the recent cases wherein the Honorable Supreme Court tried its level best to render justice. You may be knowing that in Secretary, Ministry of Defense versus Babida Punia and others, 2020 case wherein permanent commission should be granted to men in the army, regardless of their service. Clearly stated, even in army, as per army rules, they were not allowed to occupy a position beyond a particular level. But the court held that, having been allowed them to work to this extent, how can you deny? How can you deny? And clearly stated that it is violative of Article 14 of the Indian Constitution and declared that it is illegal. Like the Federation of Obstetric and Gynecologic Societies of India versus Union of India and others. While upholding the constitutional validity of Section 23 of the Conception and Prenatal Diagnostic Techniques, a Prohibition of Sex Selection Act 1994. The bench comprising of Justice Arun Mishra and Justice Vineet Saran observed that the female foeticide is a most inhuman, immoral, and anti-social act. Clearly stated. Joseph Singh versus Union of India. The 5-judge benches unanimously struck down Section 497 of IPC, saying that it was unconstitutional, since the very basis for criminalizing the adultery was the assumption that a woman is considered as a property of husband and they cannot have relations outside the marriage. The said section violated of the right to privacy as well as liberty of woman by discriminating against the married woman and perpetuating the gender stereotypes. The same is a case happened in the case of Dhanama versus Suman Sarpar versus Amma. The right of a daughter to be entitled to an equal share as a son in the ancestral property, including daughters who were born before Hindu Succession Act 1956 came into force. Supreme Court has held that daughters who were born before enactment of Hindu Succession Act 1956 are entitled to equal shares as son in the ancestral property. Like that, so many cases. Rakshan Sharma versus Arun Sharma. The custody of the child below 5 years should be with the mother, who was well educated and self-sufficient, whereas the father was jobless. Even if the father is jobless, now it has been clearly stated that from the hands of Justice Vikramjit Sen and Justice C. Nagappan, categorically stated that the father's right as a guardian over the property, but will not cover over the child who is below the 5 years of age. It was also stated that no provision of any law or act disqualifies mother with the custody of the child after 5 years of age. This case was considered to be a landmark case because it exclusively specified the right of the mother to have custody of a child below 5 years of age, provided that the mother is not unfit for the same. That is the only occasion they can exclude. All other occasions, mother can claim the custody of a child below the age of 5 years. The same is a case with lot of Sujitra Srivastava and the Chandigarh administration, Shreya Balu versus Union of India, Gaurav Jain versus Union of India and others. In all these cases wherein, in Gaurav Jain versus Union of India and others case wherein the children of the prostitutes have the right to equality, opportunity, dignity, care, protection and rehabilitation so as to be the part of the main street of social life without any pre-stigma attached to them. The court categorically held. In a very recent case, November 18th, 2021, Attorney General of India versus Sadish and others, the Apex Court passed the verdict of Mumbai High Court by saying that skin-to-skin contact is not necessary for sexual assault, but sexual intent is enough for under POSCO Act. See, in the above series of cases, we have lots and lots of cases, but all these cases wherein Supreme Court, to the maximum extent possible, could achieve the gender justice to the maximum. And we have, as I already told you, we have sufficient legislative provisions, we have sufficient judicial safeguards, and even we have sufficient international protection also. As rightly said by Ma'am Usha Ma'am, from UDHR and certain provisions of United Nations Charter, the next improvement in this field, the Convention on Elimination of all forms of discrimination against women, CEDAW, was adopted 1979 by the United Nations General Assembly, which consisted of lot of provision to safeguard the interest of women. Conventions against discrimination in education was adopted in the year 1960 itself. That was also giving heavy guarantee to the women folk. The Vienna Declaration and Program of Action, a human rights declaration adopted by the consensus of the World Conference of the Human Rights on 25th June 1993 in Vienna, also addressed the women's right. The Declaration of Elimination of Violence Against Women was adopted by the United Nations General Assembly in the year 1993. 20-year Cairo Program of Action was also adopted. Inter-American Convention on Prevention, Punishment and Eradication of Violence Against Women, also known as Belém de Pará Convention, called for the end of violence and discrimination against women. At the end of the Fourth World Conference on Women, the United Nations adopted the Beijing Declaration, 15th September 1995, a resolution to promulgate a set of principles concerning gender equality. The same way, United Nations Security Council Resolution 1325 also confers certain rights and protection of women and girls during and after armed conflicts. The Maputo Protocol guarantees a comprehensive rights to women, including the rights to take part in the political process, to social and political equality with men, to control their reproductive health, and end to female genital mutilation. This was adopted by the African Union in the form of protocol to the African Charter on Human and Its Rights and came into force by 2005. The European Union Directive 2002 on equal treatment for men and women as regards access to employment, vocational training and promotion and working condition. It states that harassment and sexual harassment within the meaning of this directive shall be deemed to be discrimination on the grounds of sex and therefore it is prohibited. Here, Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence, the first legally binding instrument in Europe in the field of violence against women, came into force in 2014. Council of Europe Gender Equality Strategy also confer combating gender stereotypes in sexism, preventing and combating violence against women, guaranteeing equal access of women to justice, achieving balanced participation of women and men in political and public decision making, achieving gender mainstreaming in all policies and measures. So, from the UDHR and United Nations Charter to this extent, the international covenants also giving guarantee to protect the interest of the female folk. That is, by which they wanted to ensure the gender justice. So, we can come to a strong conclusion that international community also paves the way for to ensure gender justice and gender equality in good spirit. Therefore, ladies and gentlemen, the future of women will be bright only if social evils like inequality and female feticide undergo complete eradication from the society. Specific laws, policies, and rules which provides empowerment to the woman need to be developed so that they can progress better in different fields. Targets should be set up for the completion of tasks such as zero female feticide by the year 2530. That is the target. So, the future of women is full of success in every field they pursue. They have numerous golden chances starting from school level to professional careers. Today, women are being boosted up to do better in the areas of interest by family members, especially after marriage. Female have no foolish restraints to be their feet and hinder their path to success. Therefore, one famous author, Albert Einstein, said, "The hand that rocks the cradle rules the world." Yes, it is being implemented in different parts of the world. Ladies and gentlemen, many conferences, symposiums, debates, wherein we had sufficient discussion about human rights and gender justice since 2 to 3 decades. But still we could not come to a firm conclusion that do we have sufficient international protection? Do we have sufficient constitutional protection? Do we have sufficient legislative protection? Do we have sufficient judicial protection? Do we have sufficient enforcement machineries? Do our people of this country have sufficient knowledge about human rights and gender justice? I am leaving all these questions to this international conference to decide it in a systematic way. Till then, thank you. Thank you very much to one and all. Thank you.
Thank you, sir, for those insightful words. Today, we are also blessed with the presence of a well-acclaimed professor, Dr. Yogesh Pradhav Singh, Professor of Law, National Law University, Odisha, who has received his LLM from National Law School of India University, Bangalore, and LLB from the University of Allahabad. His doctoral thesis, entitled Contribution of Dissenting Opinions of Indian Supreme Court Judges to the Indian Legal System, a Critical Evaluation, is recognized as a significant contribution to the understanding of voting patterns of judges in the Supreme Court of India. I'm truly honored to invite Professor Dr. Yogesh Pradhav Singh for a special address. Sir, please.
Thank you very much. Professor Sunny, Vice Chancellor NLU Kochi, Professor Uke, Vice Chancellor NLU Mumbai, Professor Santosh, Vice Chancellor Tamil Nadu Ambedkar Law University, Professor Usha Tantan, Professor and Dean, Law Faculty, Delhi University, Mr. Nagraj, Professor Harendran, and all other distinguished panels, members, and participants. A very good morning to all of you. I am grateful to Kerala Law Academy for giving me this opportunity to speak, to share my views. Though in order of protocol, it should not happen that after presidential address, we should invite any other speaker, but we'll share my views. I heard Professor Usha Tandon when she was referring to fundamental rights and the Constitution, and how we study Constitution and these rights from gender perspective. I also listened Professor Santosh, who gave a very comprehensive, elaborate presidential address where he narrated so many cases where Supreme Court and high courts also sometimes they have given enforced gender justice and rights of females. But I think if we study Constitution, if we study the judicial decision making, Dosar has given a long list of cases where Supreme Court tried to enforce, but sometimes I find problems and difficulties in comprehending some of the decisions of the Supreme Court. So I thought I would bring some of the decisions of the Supreme Court, which in my opinion is not a progressive approach taken by the Supreme Court. After the commencement, because I think we have habituated to live a paradoxical life. And the Supreme Court also sometimes give this kind of illustration, paradoxical illustration. What they preach and what they do is completely different. After the commencement of the Constitution, Indian courts attempted to use this newly granted right to equality to promote gender justice. But the cases of early decades, if we analyze, we find that courts have adopted protective approach, what Professor Usha Tandon was referring, and considering women as a weak who requires protection, under the Constitution, a special protection under the Constitution. The courts used Article 15, Clause 3 to uphold some of the special provisions which are made in the favor of women. So this protective approach, which was taken initially by the court, in my opinion, was not a progressive approach, because this focuses more on formal equality rather than substantive equality. Treating men and women equal as exactly the same, what madams referred sameness doctrine, was the outcome of formal equality. But what Constitution wanted and what we wanted, substantive equality, which requires appreciating the differences between men and women. And these differences do not make women inferior, or these differences do not make other gender inferior in any way, but it requires only differential treatment. Like should be treated likely and unlike should be treated differently. This was the concept of substantive equality which we wanted to ensure. In some cases, unfortunately, we also find a patriarchal mindset. And what is more problematic is that this we can see even in recent times. I can understand in 1950s, 60s or 70s, but we find cases even in recent time. I'll give you example. Prakash versus Fulvati, 2015, where Supreme Court refused to give retrospective effect to a very important social welfare legislation. In 2005, amendment was made in Hindu Succession Act, which gave daughters right first time to be recognized as a co-partner. This was a pro-gender justice judgment. The Karnataka High Court was very progressive, and the High Court read that we should give benefit of new amendment to the daughters. But when matter reached to the Supreme Court, we got only disappointment. Instead, in spite of this fact that Supreme Court itself in 2009 has held that any development in law will inevitably apply to the pending proceedings, Supreme Court refused to give retrospective effect to this social welfare legislation. And very strangely, in the judgment, the Supreme Court mentioned about the discriminations which happens under some other personal law, and they referred Muslim personal law to be more specific, which was not even in dispute. In 2016, we find another judgment, Narendra versus K. Meena. Same bench probably passed another very unfortunate, strange order. And the judges explicitly held that Hindu traditions recognizes that a wife after marriage is supposed to fully integrate herself with her husband's family. And if she refuses to live with her in-laws, it would amount to cruelty, and the husband would be entitled to divorce under the Hindu Marriage Act. Is it not paradox? In this case also, the High Court had ruled in the favor of the wife. So sometimes I feel that our high courts are more progressive. But the Supreme Court reversed the decision of the High Court and observed that in India, generally people do not subscribe to the Western thought, whereupon getting married or attaining majority, the son gets separated from the family. In normal circumstances, a wife is expected to be with the family of the husband after the marriage. She becomes integral to the form, integral part of the family and the husband, and normally without any justifiable strong reason, She would never insist that her husband should get separated from the family and live only with her. In 2017, another strange order from the Supreme Court, after noting the misuse of Section 498 capital A of the IPC, which talks about punishment for the cruelty, and the low conviction rate, observed that there should be no automatic arrest on charges of cruelty. But later in 2017, another three-judge bench of the Supreme Court, led by the then Chief Justice Deepak Mishra, going beyond the prayers made in this case before the bench, they agreed to review the earlier division bench decision. This is one of the biggest problems, in my opinion, in the decision-making process, because we don't find consistency in the decision-making process. And why this inconsistency? Because we have multiple Supreme Courts. Supreme Court sits in benches. In recent times, Supreme Court gave 2-3 important judgments. If we analyze from gender perspective, we can refer to Saira Banu versus Union of India, where Supreme Court, after a long time, several times matter was brought before the Supreme Court, and Supreme Court was saying that this is not the job of the Supreme Court, this is a matter for the government to decide. But finally, in Supreme Court in Saira Banu agreed with a fractured mandate of 3:2 and declared that Arctic triple talaq is arbitrary. We have example of Safin Jahan, Hadia case, wherein in 2017, Kerala High Court annulled the marriage and called this marriage a sham. And the judgment of Kerala High Court was also very strange, where it observed that marriage, being the most important decision in the life of a girl, can only be taken only with the active involvement of the parents. Matter reached to the Supreme Court, and we find a very strange approach when Justice Kehar, he ordered, or he wanted, a national NIA probe, National Investigation Agency, NIA probe, to investigate into marriage. Is it a joke? But fortunately, Justice Kehar retired and better senses prevailed over the bench, and the justice was done. We have Sabrimala judgment. The paradox lies in the fact that Supreme Court, which for the first time laid down guidelines and norms for preventive sexual harassment, we celebrate Vishakha judgment because there was no law at that time, and Supreme Court tried to implement the principles laid down in CEDAW, but failed to apply those guidelines when it came to itself, when Chief Justice of India was alleged for sexual harassment. And a bench consisting all male judges was constituted in the Supreme Court. The reason is Supreme Court's double moral standard towards gender justice. Despite its preaching how vital is gender justice in the constitutional scheme of things, we have a series of judgments where Supreme Court has preached. Very recently, Supreme Court has given this verdict that sexual orientation falls under right to privacy, and that a person's sexuality is an essential attribute of privacy. Puttuswamy judgment Unanimously, 9 judge bench said right to privacy is the integral part of right to life. And then finally, Yogesh Singh Johar, Supreme Court, after a long time, after a long movement, finally came to the conclusion that Section 377 is arbitrary. Section 377 of the IPC is archaic, and it was struck down. But the court fails to implement when it comes to its administrative side of functioning, particularly in the decision-making process of the collegium that selects judges for the Supreme Court and High Court. When matter comes that Mr. Justice Saurav Kripal should be appointed as a judge of the High Court, then the Supreme Court forgets all these principles. And finally, now again, the Supreme Court has realized that we are committing mistake, or we should not go back from what we have held in Puttaswamy or Yogesh Singh Johar. The Supreme Court has finally recommended his name to be elevated as a judge of the High Court. The experience of females has not been really included in our laws, and in 7 decades, in more than 7 decades, in fact, we have a very limited few number of judges in the highest courts, constitutional courts, which has, in my opinion, a bearing on gender justice. The only female judge was not included in Saira Banu judgment. It was called multi-religious bench, but women was not given representation in the bench. In 72 years, 73 years, how many judges? Only 8 or 9, or maximum 10 judges. They reached to the Supreme Court. They were appointed judges of the Supreme Court. How many judges are in the High Court? The total, around 1,100 judges in the all high courts of the country. We have around 90 judges, women judges. And that is why I mentioned that we are habituated to live a paradoxical life. If we really want gender justice, if we really want our Supreme Court to implement and enforce gender justice, what it has preached in many cases, I think we should appoint more women judges in the High Court and in the Supreme Court also. I would stop here. I think many senior people, they have already given a comprehensive view on gender justice. So thank you very much for giving me this opportunity.
Thank you so much, sir, for your words of wisdom. As the theme for today's session is human rights and gender justice, let us see the various insights of our students through a quick question-answer survey.
It's not a game, it's a redskin.
Domestic violence is deeply entrenched and widely prevalent in India. The National Crime Records Bureau 2019 reports that a majority of all the 4.05 lakh cases under crimes against women are reported and registered under Section 498A of the Indian Penal Code.
The section deals with cruelty by husband or his relatives. Section 498A of the IPC is a criminal law that protects married women from their spouse or the relatives of their spouse from inflicting any form of cruelty against them. However, despite having a large number of cases against women, domestic violence is systematically still known to be a very well underreported crime.
But how aware are we regarding the harsh reality of domestic violence in our own country? Thus, as a part of our 9th International Conference on Human Rights and Gender Justice, Let us see through a quick question answer survey.
Do you think domestic violence cases have risen during the COVID-19 lockdown?
Actually, I think that during the lockdown time it's increasing and more cases are coming out.
Yeah, I have.
Yes.
Yeah, sometimes.
Yes.
Yes.
Why do you think domestic violence victims find it extremely difficult to speak up or get the necessary help?
They don't want to raise any questions against that.
Domestic violence happens everywhere and no one tries to change it out.
Not all, about 90%.
No, women are more considered like commodities. So,
Do you think domestic violence heavily stems from a strong patriarchal mindset?
Yes.
Sometimes
No.
they want to suffer the domestic violence.
First of all, നമ്മുടെ priority കൊടുക്കുന്നത് നമ്മുടെ പാരൻസിനാണ്.
the girl's own family does not give them any help.
Will a case of a man being victim to domestic violence ever reach the same level of importance to that of a female victim?
Yes, I think.
Nothing to say.
Men are not taken serious. It's like how our society is like.
No, I don't think so. As the society is more developed, I don't think it is now happening in the society.
No, never.
More headlines are being made for women and not for men.
Hope you all enjoyed such an insightful video. Gratitude is not only the greatest of virtues, but the parent of all others, says Searso. From the bottom of my heart, I welcome Professor Harindran K, Principal of Kerala Law Academy Law College, a man with charismatic personality and extreme energy. Sir, please.
Good afternoon to all. Most respected Professor K.C. Sunny sir, Professor Dr. N.S. Santosh Kumar sir, Professor Dr. Usha Tantan, Professor Dr. Yogesh Pradhav Singh, Dr. Pradeep Kumar Das sir, our Director Advocate Nagaraj Narayanan, Professor K. Anil Kumar sir, and other distinguished invitees, delegates, my colleagues, participants, students, parents, and other well-wishers of this institution. As you know, this is our 9th international seminar conducted by Kerala Law Academy Law College in association with the CALSAR, the Center for Advanced Legal Studies and Research, on the topic human rights and gender justice. Anyway, this international seminar has been proudly inaugurated by our chief guest, Professor K.C. Sunny sir. As you know, he is the Vice Chancellor, University Kochi. He is my guru and teacher. He is an outstanding academician and efficient administrator and a constant motivator in the academic, legal, and educational field. While he delivering his inaugural address here, he shared his 41 years of experience with this institution and also the experience with our founder, director, Dr. N. Narayanan sir. And he also shared his great views and versions relating to the human rights and gender justice. And while delivering the presidential address, the Professor Dr. N.S. Santosh Kumar sir called him as son of Law Academy. It is very apt if the long-standing experience of the Professor Dr. K.C. Sunny sir with this institution. We are all proud of that words of Professor Dr. N.S. Santosh Kumar sir. Anyway, on behalf of Kerala Law Academy, Law College, and CALSAR, we expressing our sincere thanks to you, sir. Professor Dr. N.S. Santosh Kumar sir, he is the Vice Chancellor, Tamil Nadu Dr. Ambedkar University, Chennai, and held several administrative posts such as the Director of Legal Studies, Principal of Madras Law College, the government law colleges at Coimbatore, Tiruchi, and Tirunelveli. He is an excellent academician and a good administrator. Despite his busy schedule, he has shown his willingness to participate in this international seminar. He shared or he compared the status of the women with a thermometer to check and measure the temperature of the progress of a society or of a nation or of a society. So anyway, his speech was very thoughtful, thought-provoking, and informative one. On behalf of Kerala Law Academy Law College and Khalsa, we are expressing our sincere gratitude to you, sir. Professor Dr. Usha Tantan, Professor of Law, Campus Law Center, University of Delhi. Our Director, Advocate Nagaraj Narayanan sir, elaborately introduced Professor Dr. Usha Tantan in a very gentle manner. According to him, he is a world-renowned scholar for her work on human development, focusing on environmental protection and women empowerment. She delivered very elaborate keynote address here, highlighting the gender equality, gender equity, gender neutrality, gender parity, and also the gender protective laws, etc., etc. His speech was very beneficial and fruitful as far as law students are concerned. In the name of Kerala Law Academy Law College and Khalsa, we are exposing our sincere gratitude and thankfulness to you now. Professor Dr. Yogesh Pradhav Singh, he is the Professor of Law, National Law University, Odisha. He constantly writes in the field of law in reputed law chronicles, national and international journals, etc. He delivered the special address here. We expose our sincere gratitude, you sir, for being a part of this seminar and for imparting us your valuable knowledge and views. In the name of the Kerala Law Academy Law College and Khalsa, we are expressing our gratitude to you, sir. Advocate Nagaraj Narayanan, sir, he is our director. He is a special prosecutor and a government pleader of Forest Department in High Court of Kerala. He is also a member of Bar Council of Kerala and adjunct professor of Nuvals Kochi. After he became the director of this institution, he changed the pace and face of this institution within a short span of time. Thus, he created a fast-paced environment here, and he is maintaining the same constantly and successfully for the students and even for the teaching faculty also. Here, he introduced and welcomed all the eminent and prominent personalities in an elaborate, gentle, and classical manner. We are expressing our sincere thanks to you, sir. Professor K. Ankumar, sir, he is a general convener of this seminar. No doubt, he is an efficient and effective executor of all programs conducted so far here. He is the real creator and designer of these events. By having conducting all those programs so far here, he proved to be a well-planned, well-systematic organizer and a successful executor. We are expressing our sincere gratitude and thankfulness to you, sir. I also take this opportunity to congratulate and thanks to our teaching faculty, especially the faculty conveners, Dr. Lakshmana Saraswati, Achida Nair L, Ranjini Pannan Sheila, Ladhika Nair, the teacher, Advocate Binu PM, and also our student conveners Ajay Y, Rishikesh, Sruthi Kannan, Darshana Vikraman, Arjun PM, Sri Durga MU, Goviga Shashi, Nanda Kishore, Abhirami, Nandu Aras, and also Ashik Muhammad. And I also take this opportunity to thank all the invitees, participants, moderators, students, parents, and all well-wishers of this institution. Thank you once again. Thank you.
Thank you, sir, for expressing your heartfelt word of thanks to this inaugural session. I use this opportunity to extend my gratitude towards you too, sir. Thank you. And now we're nearing the end of the inaugural session. This is all on behalf of Kerala Law Academy Law College. I thank all of you for joining and remaining with us till the end of the session. I would like to extend my gratitude towards Advocate Nagaraj Narayan, sir, Director, Kerala Law Academy, Harindran K, sir, Principal, Kerala Law Academy, Anil Kumar G, sir, Professor, Kerala Law Academy, eminent guests, faculty conveners, our student conveners, technical as well as non-technical staff who worked around the clock to make this event a grand success. This is Hanan, your student moderator for the session, signing off. Thank you and have a great day.